who issued orders and who shall be responsible for the crimes or most responsible for the crimes. And for that reason, we should not resort to other criminal laws to interpret such a case. We only need to look at the law available before us. An instigator shall only be liable to punishment if the commission of or attempt to commit felony or misdemeanor is established. Articles 1 and 2 of the ECCC law and the response by the Office of Co-Prosecutors to the appeal brief by the Defense Counsel, the co-prosecutors indicated that there is no provision binding it to prosecute perpetrators of security centers all across the country. For that reason, we can conclude that perpetrators do not fall within the jurisdiction of this particular tribunal. According to Article 28 of Cambodian Penal Code, which states that only the instigators shall be liable for the crimes. So reading this in the code and the law of the ECC altogether, we can feel that they are enough to interpret who shall be responsible for the crimes. This article is very consistent with Articles 1 and 2 of the ECC's law and Article 1 of the agreement, which is set to prosecute two categories of people: the senior leaders of DK and those who were most responsible for the crimes. The most responsible people for the crimes, as referred to Article 1 and 2 of the ECC law and Article 1 of the agreement, are those who instigated or initiated or ordered the commission of the crimes as set forth in Article 28 of the Cambodian Penal Code and Rule 87 of the ECC internal rules. The prosecution and the trial chamber must examine the evidence submitted by the parties, and particularly the evidence the co-prosecutors have located. The secret decision of the CPK of 30th of March 1976. There are a lot of prisons, and the prosecutors submitted that S21 was a unique prison. However, the Defense Counsel believed that both the accused and other civil parties were victims of the crimes committed at those detention facilities. My family members have also been victims of other prison centers or security centers. I believe that there are more than 200 security centers, and there is another security center which is also part of the center party. It was near Wat Botum. We call it S21. It was not really rather S71, it was not included. International law cannot be applied to an individual, but a state, an international organization, and multinational company. It is therefore only senior members and head of the government who shall be held accountable for crimes against humanity as they represent the state. Likewise, only the leaders of the party who hold senior positions of power and who made Council, thank you for reminding. Actually, I was rather fast because we had much to say during the time limit. Likewise, only the leaders of the party who hold senior positions of power and who made decisions on policies which give rise to the commission of crimes against humanity, grave breaches of Geneva Conventions of 12 August 1949 shall be bound by Article 1 of the agreement. agreement, Articles 1 and 2 of the ECC law, Articles 24 and 28 and Cambodian Penal Code. Doge were only chief of prison guards. He was among the chiefs of the guards of the 196 security centers across Cambodia. He is therefore not bound by Article 1 of the agreement and Articles 1 and 2 of ECC law. Thus, this does not mean that judges shall make sure they hand down their decision with the adoption of a decision by any of the other preceding tribunals. Furthermore, there is no provision whatsoever in the agreement and the ECC's law obliging the co-prosecutors to charge a former chief of security center. Even the chamber itself is not legally obliged to try perpetrators who were the heads of the security centers around the country, including the chief of S21. The applications of international laws can only be resorted to when the laws in Cambodia are not enough and that they must be consistent with the tradition of the law being in use. Because the ECCC is not an independent tribunal as ICTY. According to Article 12.1 of the agreement, the ECCC is within the sovereignty of the country which follows the civil law tradition. And for that reason, ECCC is bound to apply the civil law. And if the chamber tries to resort to using other international laws on top of what the available existing law, it violates or disregards all the existing laws. So in conclusion, the ECCC law is fully employing the civil law tradition. For that reason, we have to be bound by the principle Nullum Crimen Sine Lege. The exercise of power expansion by the chamber violates the Cambodian Constitution, Cambodian Penal Code concerning the exercise of power by the judges, and that only the Constitutional Council is obliged to interpret the law, not the judges themselves. So the interpretation that Article 1 of the agreement, which reads that crimes under DK shall be prosecuted, and that the trial chamber indicated that the definition itself is not clear, that it had to resort to the interpretation or decisions made by ICTY and ICTR. To the defense counsel, it is not proper because it against the rule of Nullum Crimen Sine Lege. And the accused himself does not fall within the jurisdiction of the court. And since there is no law applicable can be sought to prosecute the accused, there is no other law that can be used in this context. Article 1 of the agreement between the United Nations and the Royal Government of Cambodia and Articles 1 and 2 of the ECC law have to be well applied, otherwise it really infringes the rule of law. Also, infringes the law on treaties or of treaties. And the interpretation of the law shall not fall out of the context of the law as set forth in the treaty signed by the government and the United Nations. Both in Tokyo and Nuremberg, the tribunals ban the chamber to expand its power autonomously. And as a result, these tribunals strictly obey the rule by not allowing judges to expand its exercise of power or discretion. For example, after all, they did not really bring to trial other forces during the war, although a lot of people were killed under the forces. The criminal jurisdiction under ICTY and ICTR is not different from this court. And at that tribunals, there has no personal jurisdiction against individuals because the crime were committed from political ideology. However, at the ECCC, personal jurisdiction has been well established, and that the purpose of the establishment of the extraordinary chambers and the courts of Cambodia is to prosecute senior leaders of the Khmer Rouge and those who were most responsible for the crimes. So the application of international instruments, for example, customary laws, is against the ECC law. Second ground, the error on sentencing. Paragraph 30 and 31 of the judgment reads, so on and so forth. The just cogence, which is a general principle of international law, is de facto a norm which cannot be violated and from which no derogation is ever permitted. Every individual involved shall be punished regardless of privilege, social status, duress, or circumstance. Nonetheless, it is noted that the ECCC has personal jurisdiction over an individual. It is noted in the preamble part of the agreement between the United Nations and Royal Government of Cambodia that the General Assembly of the United Nations, in its resolution 57/228 of 18th December 2002, recalled that the serious violations of Cambodian and international humanitarian law during the period of democratic Cambodia from 1975 to 1979 continue to be matters of vitally important concern to the international community as a whole. Whereas in the same resolution, the General Assembly recognized the legitimate concern of the government and the people of Cambodia in the pursuit of justice and national reconciliation, stability, peace and security. And whereas the Cambodian authority have requested assistance from the United Nations in bringing to trial senior leaders of democratic Cambodia and those who were most responsible for the crimes and serious violations of Cambodian Penal Code, international humanitarian law, and custom and international conventions recognized by Cambodia that were committed during the period from 12 April 1975 to 6 January 1979. The preamble expressly states that there are only two categories of people who shall be brought to trial, although the universal principle contemplates prosecuting anyone who has committed any of the aforementioned crimes in the preamble. The United Nations task is therefore limited to assisting Cambodia, and that the trials shall be compliant with Cambodia and international customary law, not the common law. This tribunal is not bound by the common law. The civil law principle of nullum crimen sine lege, or no crime without law, is always applied in accordance with the existing national and international laws. Since the ECC's law observes the prosecution of only two groups of people, Therefore, no one is authorized to seek a supplementary decision from any other judges to enable them to define the personal jurisdiction other than from those at the ECC. I'm very sorry for speaking that fast because of time constraints. In the introductory part of the trial chamber's judgment in case 001, the trial chamber has failed to make use of the ECC's law or Cambodian penal code such as articles 4, 5, 24, 25, 26, 28, 32, 35, 36, and 46 to prove the legality of the evidence. Instead, the judgment is flooded with jurisprudence from ICTY, ICTR, ICTS, Hochschool, and Nuremberg. Such decision has not only called into question the right to receive international assistance, but it also expands the scope of interpretation of the law by analogy. When the power of the chamber has been expanded through its application of arguments from jurisprudence. By so doing, this chamber totally applies common law, which is contradictory to the civil law, which has been the exclusive law of Cambodia for a long time. The report by Mr. Craig Etchison has been placed in the case file, but the evidence itself has not been brought before the trial chamber during the trial hearings. Document number 2 is about F14 or ERN 00626210. This document was submitted to the UN Commission of Experts, prepared by DCCAM experts. In that statement, Kang Kek Il was the chief of San Tebal, or the prison's guard, and those who were most responsible for S21 were Son Sen and Pol Pot. According to the transcript of the hearing and the statement by the experts, before the co-investigating judges and co-prosecutors, Kang Kek Il alias Dutch made it clear, and also according to the report of Dr. Krajasan, it stated that Nuon Chia was also involved in overseeing S21. Kang Kek Il also indicated to me that Nuon Chia told him that the genuine chief of S21 was Nuon Chia himself, not Dutch, and because Dutch actually at one point challenged the interrogation of the prisoners at S21, and that incident prompted Nuon Chia to claim that Nuon Chia himself was the chief of the vicinity, and that he said that you, Dutch, were not the chairman of S21. This incident happened when Son Sen was transferred to the battlefield, and that Nuon Chia, rather, was his successor, I mean Son Sen. And Nuon Chia made it very clear before Dutch at that moment, as Dutch indicated. By conclusion, I would like to submit that the judgment by the trial chamber has been rendered from erroneous ruling concerning personal jurisdiction over the accused, because the chamber has failed to review exculpatory evidence. There is another piece of evidence to prove that exculpatory evidence has not been subject of the debate before the chamber. According to the statement by the judicial police, Mr. Bastin, who indicated that co-investigating judges Marcel Lemond and Mrs. Anna Austin ordered or advised their colleagues not to investigate exculpatory evidence. It is a very stupid act by them, and it's really against the due process, because the co-investigating judges shall investigate exculpatory and inculpatory evidence, and these pieces of evidence shall be presented before the chamber. These are the subject of our argument, and that's why our client does not receive fair trial. Thank you, Your Honors. The President. Next, we would like to proceed with the co-rapporteur to put any questions to the defense counsel should they wish to do so. Judge Yasinke, you may proceed.
Mr. Kha Saviut. Mr. Kha Saviut, Defense Counsel, may I have your attention, please? Right. Your main argument is that the jurisdiction of the ECC is limited to senior leaders of the Democratic Cambodia who are most responsible. Right? That was your main argument. Now, what is the legal basis on which you said that the senior leaders of Democratic Cambodia and those who are most responsible should be read conjunctively instead of disjunctively? Because your main argument is that the jurisdiction of the ECC is ousted on the basis that you are not a senior leader of the Democratic Cambodia. So would you tell us the legal basis on which you sought to oust the jurisdiction of this court?
Counsel Kasawut. Mr. President, Your Honors, and the Court. To respond to your inquiries and regarding this tribunal, Article 1 states that only senior Khmer Rouge leaders and those who were most responsible for the crimes shall be prosecuted. And this piece of document, as I indicated, is the ground. And this document has been from the party center, from Pol Pot, the decision made by him. So the standing committee of the party center issued this decision, and the details of which can be found in this piece of document. So the senior leaders of the DK were the standing committee, 7 people, and include another 3 and I think we have already submitted in our submission these names of people involved. During communist regime, the party ruled the country, leads the country, and we people had to be to abide by the party's rule. This means that the DK order or rule that people within and outside the rank can or could be smashed. So the standing committee issued or rendered power to 4 groups of people to smash. For example, there were 7 zones, and the secretary of each zone is liable for committing for smashing within and outside the ranks. And number 2, the office surrounding the center. So Office 870 and its secretary was in charge of this execution of the order. The President interrupts. Mr. Counsel, actually the document has already been put up before us. The question before you is more about whether the term, the language senior leaders of Democratic Cambodia and those who were most responsible should be read disjunctively instead of conjunctively. And if so, would there be any other laws that you can really refer to? And you already indicated that Article 1 of the ECC law as a reference, but would you wish to refer to other laws? And please be brief. Council Kasabot, I think I have already made it clear, according to Rule 11 bis, concerning the jurisprudence of ICTY, concerning the interpretation regarding senior leaders. Senior leaders here refer to those who have high positions, de facto and de jure, holding the power that can be regarded as the senior leaders, not the middle level people. So I am referring to Article 11 bis of the international jurisprudence, Your Honors.
Counsel, you would observe that in the middle there is the word "and." Senior leaders of Democratic Cambodia and those who are most responsible. It is in view of the presence of the word "and" that I asked whether this expression should be read conjunctively or disjunctively. So without referring to documents, would you give us a legal basis, please?
Counsel Kong Ratiri, Your Honors, to respond to this, we fully agree that the conjunction "and" is well used, which means even those who were most responsible for the crime shall be prosecuted, and that we look at the mens rea of the person who committed the crime. Those who only hold the senior position could issue order, and that people at a lower rank could not really make any decision to kill people. That's why such people would be subject to the orders. And in the ECC law, the expression, the language has been well framed that senior leaders of the DK and those who were most responsible. So people who were most responsible for the crime should be separate from those senior leaders.
Say that again, Mr. Counsel. Say last. Your last statement.
The word "and" based on the Article 1 of the agreement between the UN and the government, and Article 1 and Article 2 of the ECC law, that the senior leaders of the Democratic Cambodia and those who were most responsible for the crimes. The word "and" it means they are it is conjunctive. It means those who were most responsible for the crimes must be those who were senior leaders of Democratic Cambodia. Otherwise, they would not be most responsible for the crimes. I hope I am clear, Your Honor. The President, thank you for your clarification. It is now appropriate for the adjournment. The court shall resume at 1:30 p.m. this afternoon. The council may my client also have a break and go for lunch. Without your permission, he won't be able to go. The President's microphone is off. The graphic, all rise.